Finally, operating a business from home in a POA. So, with COVID-19, we've all really had to work from home unless you were an essential employer or employee for this COVID-19 pandemic. And it's really changed the face of how people operate and how businesses operate and your ability to work from home. So those are kind of the areas we're going to hit on. We'll start with short-term rentals and POAs first. So as Mitch mentioned, this is a little bit of a complicated area. It didn't used to be, but this recent Texas Supreme Court case that came out in 2018 added a lot of confusion to the mix. It's caused confusion amongst news reporters, confusion amongst owners, amongst realtors, and it's taken management companies and legal counsel some effort to really explain how narrow in scope that Texas Supreme Court case was. And we'll dig into that here. But what kind of listings do we typically see for short-term rentals? Single rooms, so renting part but not all of the home or condominium unit that you're dealing with. A garage apartment. Maybe a home has got a garage apartment in their back, not connected. Finally, the entire house, right? So a homeowner may rent the entire home and then leave and stay elsewhere for that weekend, or maybe they've just got an investment property and rather than do longer lease terms of a year, 2 years or more, they're just doing the short-term rental because they are making more money at it. So examples of short-term rental software that a multitude of people utilize: HomeAway, Airbnb, VRBO, Room-O-Rama, etc. So a lot of those names you should be familiar with. All right, so why? Why are people doing this? Why has it become so popular? Well, the web has really opened up a variety of options for homeowners to make that supplemental income, that additional income to support whatever it is they want to support. So method of earning additional income, you've got other owners that are actually buying second, third, and fourth homes and using them as investment properties. You've got people who will get together, they'll form an entity, and then that entity will be in the business of buying homes in communities, converting them to short-term rental properties, and then just making the money, right? So you invest your money in, you get 15 investors who contribute a dollar figure. That dollar figure adds up pretty quickly. So it has the capital needed to make those home purchases and convert them into short-term rentals. Taking advantage of high attendance events. Previously taking advantage of high attendance events, right? So COVID-19 has kind of done away with this reasoning. Ultimately, it's going to be back, right? But Final Four, Super Bowl, rodeos, Austin, city limits, there's a wide variety of events depending on the area of the hill country you live in, or if you live elsewhere in Texas, that is really going to attract persons to stay in your community if you're close to one of those venues. So again, what's the appeal? It's all about targeting those vacationers. You get that home away from home feeling. So, you're going into a home that is your very own. It's not a hotel. You don't have to deal with staff or other persons staying at the hotel. It's your place. It makes you feel warm and fuzzy. And a lot of people like that feeling. So it's convenient, it's secure. You do not have to exchange money at all. Literally, you fill it out, you click a button, it draws from your credit card, and by you clicking the button, you have electronically signed a lease, signed an agreement. So it is so easy to do right now, and you don't even have to deal with the landlord, the management company, or the owner of the property. You just literally go to this Airbnb, you punch in a code if they've got one of those lockbox type scenarios, or maybe the door is electronically locked and you punch in a code. It's that easy. So ease of use it has made it really appealing to owners, or excuse me, to these Airbnbers. All right, so we've talked about all of the things that make short-term rentals so appealing to both users and owners of the short-term rental property. What about POAs? How does this affect POAs? And look, some of y'all on the phone may be okay with short-term rentals. So I'm not giving one side or another right now. It may be okay for some communities. And nowadays, at least in the Hill Country area, I've got developers that we're representing that are actually building short-term rental HOAs. They're building sections that are designed to allow for short-term rentals. So again, it depends on what kind of community you are, but most of the communities I deal with do not want the short-term rentals in. And why? Here's some of the most common reasons I see. The arrivals are just completely unsupervised. They may sign up for 2 people to stay in the home, but 8 end up staying. And there's no way for the landlord to adequately monitor that change in the number of guests unless they install cameras and monitor entrance and exit. Obviously, you probably run into a little bit of a privacy issue if you install cameras inside the home, but I do know of some landlords that install it outside to monitor the number of guests coming in to the home. So tenants bring more visitors than are agreed upon. You have an increase in noise, traffic, trash, violation of the rules and regulations. I guarantee most of the time when a tenant comes into an Airbnb, even if they're provided with the restrictions, they're not going to read them. So they don't have an understanding of the governing documents that bind the property. What happens when you don't have an understanding of those rules and regs? You're going to violate them, either because you don't care or because you don't know. And landlords are then left to deal with those consequences. Okay, so we've talked a little bit about the pluses and the minuses. One other kind of minus that I've seen, and there's some data out there supporting this theory. I actually wrote a State Bar of Texas paper on this, but it can actually negatively affect the fair market value in the community. So you may actually see a decrease in fair market value. Why? Because the homes are not as maintained. And then the noise, traffic, trash, all those other items that I mentioned on the previous slide. Okay, so tar versus Timberwood. This is the case that changed short-term rentals here in the lovely state of Texas. So, and our law firm handled it at the district court level, at the Court of Appeals level, and at the Texas Supreme Court level. So we were the attorneys in charge at all 3 levels. We won at the district court, we won at the Court of Appeals, but unfortunately we didn't win where it matters at the Texas Supreme Court level. We disagree with a lot of what the Texas Supreme Court gave us, but it is what it is. It is law now. So we've got an owner who's the plaintiff, Kenneth Tarr. He began leasing his property for periods of 1 to 7 days. Due to increased noise and trash, the association sent him correspondence saying, hey, stop renting for short-term periods. We are a residential community, and you can only use the home for residential purposes. And renting out your home on short periods is a business use of the property, which violates our residential use restriction. So keep in mind, the restriction isn't single-family residential use. It is only residential use. These restrictions were threadbare. So it's not the best case for Texas Supreme Court because the restrictions we're dealing with in this case, I think were only 4 or 5 pages long. Most restrictions, maybe your restrictions, they're probably 50, 60, 70, maybe 100 pages long. So a little bit more in depth. These restrictions threadbare. Okay, so we say business use, Mr. Tar, not okay. You better stop or we're going to have to proceed. Well, he's like, you know what? You don't have to worry about proceeding. I'm going to proceed. And he proceeds to sue the association. All right, so here's that key restriction. All tracts shall be used solely for residential purposes. So residential purpose, if it is a business purpose, that is a violation of the restrictions. And Tar argues that his tenants rented the home for a residential purpose and the use did not violate the restrictive covenants. We, of course, argued that, look, short-term rentals are a business purpose. You're essentially engaging in hotel or motel practices. And how did we kind of come up with that theory? Well, Mr. Tar was paying hotel tax in the state of Texas, in the county of Bexar. So this was down in Bexar County. So we're like, look, he's renting it out over and over again. He's entering into these transactions. Heck, he's even paying a hotel tax court. So this should be considered a business purpose. We relied on previous Court of Appeals law that supported that theory and said that this type of rental is a business use of the property and is thus not allowed. So we won at the Court of Appeals. It got appealed to the Texas Supreme Court. For Texas, you are not entitled to go up to the Supreme Court. The Supreme Court has to accept your case. And in this particular matter, the Supreme Court decided to accept it. So we've made our arguments, district court level, Court of Appeals level, gets up to the Supreme Court, and the court says, well, these people are doing residential type things on the property. So the business transactions, right? The signing up, clicking accept on Airbnb doesn't occur on the property. It actually occurs on the web. So because the transaction, because you weren't signing a lease on the property, exchanging money on the property, because none of that was occurring on the property, the court said, well, they're doing residential things on the property, like eating, sleeping, watching TV. And because of that, it is a residential use. It is not a business use and is thus not a violation of the restrictions. Now, remember, this Texas Supreme Court case did not have any restrictions on leasing. It did not say no leases are allowed for less than 30 days. Nothing in there like that. So, had that been there, the outcome would likely have been different because the court would have been required to review that restriction that says no short-term rentals less than 30 days, would have looked at this and said these are Airbnbs for less than 30 days or whatever the time period is, and thus it violates the deed restrictions.
Yeah, and I think that's, if you Google this case, you'll find just a ton of articles and ton of material out there proclaiming that, hey, anybody who lives in an HOA condominium anywhere, they can freely rent their home now through one of these websites simply because of the results or the outcome of this case. And I think it's incredibly important, especially as our boards are challenged with those assertions from homeowners, to understand that your documents, and many, I mean, most of the documents that I see have some prohibition on short-term rentals, and that should be enough to protect you in many cases, but very, I think, material difference in terms of what many cite as the reason for being able to rent out their home.
Absolutely, Mitch. And so to Mitch's point, probably about a month after this court case came out, you started seeing news reporters, realtors, other real estate, quote unquote, experts completely misinterpreting this Texas Supreme Court case. So it's very important that you make it clear to your owners that you have a short-term rental restriction that you are enforcing, which is not in violation of any case law. So hang your hat, rely on your management company, rely on Goodwin, rely on your general counsel, your attorney, if you have to get him or her involved. But you should make it very clear that you are a short-term rental restricted community, and those restrictions must be abided by. Okay, so here, that sets the stage for this new Court of Appeals opinion. We have this case floating out there with residential purpose. We can no longer use single-family residential use restriction to prevent short-term rentals. So if your declaration does not have a short-term rental restriction on it, i.e., you cannot lease your home for less than 30 days. If that's not somewhere in your documents that limits duration of leases, then you cannot prohibit short-term rental restrictions without amending the declaration. And I'm going to talk in a minute about the potential to adopt a board policy to restrict short-term rentals based on the case we're about to go into now. But generally speaking, prior to this Court of Appeals case, the rule was if you want to restrict short-term rentals, you have to amend your declaration. Now, in order to amend your declaration, the magic number is usually 67%. I'll do a quick sidebar on what that means. So if you're a single family or a townhome community that's governed by Chapter 209 of the Texas Property Code, you have the ceiling the ceiling rule or the roof rule. And it basically says if your restrictions have a higher percent than 67, let's say they say 75% of all owners to amend, the ceiling rule kicks in and it brings that number down to 67%. If, however, you have a number below 67%, the ceiling doesn't prevent the lower number. So if your restrictions say a majority of all owners to amend your declaration, that is okay. So that's the ceiling rule. For condominiums, flip the rule. It is now the floor rule. So we've got our ceiling rule. Let's do our floor rule. It provides that if the restrictions provide for a higher number than 67%, that higher number controls. So flip it. If your declaration says you need 75% of all owners to amend the condominium declaration, that number controls. If, however, your condominium declaration says you only need a majority of all owners to amend the declaration, well, it's the floor, so it yanks it up to 67%. General rules of thumb for amending your declaration. That's what you have to do up until this case to restrict short-term rentals. You have to amend your declaration. Okay, J. Bryce Holding came out 2 months ago, back in August of 2020. J. Bryce purchased 2 townhomes for the purpose of renting the properties on Airbnb for terms of 1 to 10 days. The association sent letters saying, hey, stop your activity. This is violating our deed restrictions on short-term rentals. So the J. Bryce responded by saying, hey, you don't restrict duration. You only have single-family residential use. Therefore, you can't restrict me based on Tar versus Timberwood. Here's what the association did that is different, however. The association board of directors relied on a statute in Chapter 204 of the Texas Property Code that gives the authority to the association to adopt and amend rules regulating common areas and lots within communities. So the association decided to adopt a policy under that chapter of the Texas Property Code to restrict short-term rentals. Now, their declaration didn't speak to rulemaking authority, but the statute did. And so the question is adopting a policy, which only requires board approval, not owner approval, designed to restrict short-term rentals, is that enough to enforce the rules and prevent short-term rentals? Our advice prior to this case was it may not be, which is why we recommend you amend your declaration. But the association did this and got sued. So, trial court level, we argue, again, this is another one of our defense cases. Our law firm was involved in the district court case and the Court of Appeals case. And at the district court level, we argued that 204 gives us the right to adopt rules. There's no restriction on our prevention of adopting leasing rules. So we're adopting these leasing rules which restrict short-term rentals, and that is within our rulemaking authority. The trial court agreed with that opinion. The Court of Appeals also agreed with that argument. So now we have the authority to regulate the use of our community, which includes restricting short-term rentals. Here is the caveat. Chapter 204 only applies to a few counties in and around Houston. So if you're a board member in the Houston area or a manager in the Houston area, get with your legal counsel on this case, because you may be able to adopt a rule that restricts short-term rentals, and you just hang your hat on Chapter 204 and you hang your hat on this Court of Appeals case. So the question is, what if we're not in the Houston area? What if we're in the Hill Country? What if we're in Dallas, San Antonio, Austin, the Valley, or some other area that doesn't get to use Chapter 204? So the strongest case you can make in terms of belt and suspenders is to amend your declaration, which requires a vote of the owners. And again, I talked about the ceiling rule and the floor rule, so we don't have to go into detail here. That's option one. That is your strongest option. That is the option that is really not going to be subject to attack. Option number two is to adopt a policy. What do you need to adopt a policy? Number one, you have to make sure you've got rulemaking authority in your declaration. Rulemaking authority as to the capital P property. So as to the lots and or the units, if you're a condominium, that you govern. If you have that rulemaking authority, very broad authority, the second question you have to ask is there a restriction in the declaration that allows for leasing? And if the answer is yes, you may not be able to adopt a rule. But let's assume it's not there either. There isn't really any leasing provisions in your declaration. Well, then you can the board can adopt a short-term rental policy and hang its hat on that policy, with the understanding that we do not know how a Court of Appeals may rule. We're going to rely on the J. Bryce holding that talks about rulemaking authority. So although it's statutory in J. Bryce, we're saying, well, Judge, it's statutory there, but hey, we have that same authority in our declaration, and we decided to adopt short-term rentals. So those are our two options now. Amending the declaration is the strongest one, best way to get it done, but there may be a way for you to adopt a policy through the board, not the owners, to do a short-term rental policy. So again, if y'all are having difficulty and are exploring options, get with your general counsel on this particular issue. He or she should be able to advise you.
Hey, Clint, one of the things that I get questions about from time to time from board members is what happens if we do pass an amendment to the declaration or policy, and so a homeowner purchased in the community for the specific purpose of being able to increase their income by the use of these rental restrictions. Is that person grandfathered in the case of a situation like that, where the board goes ahead and shores up their documents by writing in provisions that will prohibit this type of activity?
So what I tend to like to do is, rather than writing it in the document necessarily directly, Mitch, the board can kind of make a decision to do a delayed implementation to give the owners maybe a 6-month window to wrap up these short-term rentals and sell their property. So it gives these owners a little bit of wiggle room. Now, the next argument that can be made is, and I don't know that it's a good one, but let's go through a hypothetical. Let's say that the board decides to restrict all leases less than a year, and we've got Bob, the owner, who just rented out his home for 6 months, and the association amends the document. It gets recorded, and the association wants to immediately prosecute Bob for that 6-month lease. Why? Because it violates that year minimum restriction amendment that just occurred. There is an argument that you have to wait out the term of the lease, because when the lease was entered into, there was no restriction on 6 months, right? It was whatever term you wanted it to be. So, in that instance, I would recommend, rather than fighting that in court, wait 6 months, let that lease term out, and then Bob has to sell his lot and his property. That's not really much of an argument you can make for Airbnb, right? Because they are so short in terms of terms. They typically last anywhere from 1 to 7 days. So you can just simply wait out your 7-day period and say, well, Bob, the last lease is terminated. You've got to stop, sell the property. And if you don't want to abide by our leasing restrictions, and go about your way. Regardless, I like a little bit of a delay so that you give everybody a fair opportunity. It reduces the chance that they're going to fight you on it.
Clint, what about the idea of VRBO or Airbnb being leases? I've heard the argument made that it's not technically a lease of the property, as in the conventional nature of someone leasing out a property for a year.
Right. So, I think it's a contract, right? You can call it whatever you want to call it, right? If you don't want to call it a lease, that's fine, but it is an agreement between two parties, and you cannot rent out, lease out, exchange consideration for any period less than 30 days. And Mitch, I've heard that argument made. So the restriction amendments that we draft basically say if there is any form of consideration exchanged and the period for the use is less than 30 days, it is a violation. So, to your point, Mitch, there are certain instances where there's a website, I don't know what it may be called, like houseswap.com, where you literally switch houses for maybe a period of a week. And we try to design our documents to address those types of short-term rentals as well. So make sure your attorney drafts the language appropriately to address those sorts of arguments that the other side may make. So very, very good point.
Difference there between condos and homeowner associations, specifically anything that we need to cover on this front?
Not on this slide, but I will say generally condos have a little bit more strength in terms of short-term rentals because of 82.102 of the Texas Property Code. It actually gives the board the authority to regulate leasing. So you really get rulemaking authority plus 82.102. So you have an even better case that a policy is okay rather than amending the declaration. So Swimply, I'll address this briefly. And it's so funny. We heard about this earlier in the year. I looked this up in my community, and I've got like 3 Swimply pools that are half a mile away from me. And it's basically owners renting out their pool to whoever wants to use it for short periods. It's a mess. Figuring out new ways to make income. And I've seen Swimply pool parties where you've got 30 or 40 people showing up to this person's backyard, having a pool, creating noise, traffic, all kinds of messes. And yet the violation only lasts for about an hour or 2 hours because that's how long the pool rental is. We're designing our restrictions now to kind of prohibit this type of use. But if this may not even be a problem for a lot of communities yet, but just be aware that it's on the horizon. If you're seeing this, get with your counsel. He or she is going to have to review your documents to try and come up with a unique enforcement method because it is such a wacky thing that a lot of people wouldn't have even thought about.
And I'm seeing some dollar signs in the eyes of some of our board members asking, can I put the community's pool on Swimply?
Maybe. The answer is maybe, and it really depends on how your community's set up and how your governing documents are written. Now, if you want to go down that route and you're a community association wanting to look for some additional income, renting out to non-members, you've got to think about the increased liability potential and waivers and all that other good stuff. But the answer is, Mitch, maybe. It really does depend on the governing documents.
That'd be an interesting and contentious board meeting where that's brought up.
Yeah,
stay away from that one.
It would. So we can go on past Swimply. I think we've addressed it well. So again, concerns for POAs, liability, similar to other short-term rental issues, health and safety. Portable facilities. I mean, geez, if the pool host doesn't want to let you in their house to use the restroom, Swimply will provide for a porta potty. Geez, that just doesn't sound great. So again, I don't know that a lot of y'all are dealing with this issue right now, but if you end up if you end up dealing with it and you do not have some good restrictions, you may need to amend your declaration and or adopt some sort of short-term rental pool rule.
Yep, no doubt.
And we can move on.
Hold on 1 second.
No problem.
Just zoomed in on me. There we go.
All right. So remote working versus operating a business from home. Remote working from home has been a big help for America to maintain its economy, right? People being able to transition from the going to work every day setup to working from home, but still being able to provide the services that you would provide at work. A lot of the jobs that we have in America allow for that. So it's forced businesses to invest a lot of money on the front end to allow for that sort of work from home option, buying hardware for its employees, or maybe giving some sort of a subsidy to its employees to buy a laptop or something along those lines. But in the long run, it's really helped to diversify the workplace for America, and I think that we will never go back to how we were working prior to COVID-19, simply because businesses don't necessarily have to have the same amount of space anymore to host your employees. You can effectively have your employees at home. So for communities, now you've got a ton of owners that aren't leaving their home, that are working from home. So the question is, does it constitute a business use? Well, answering emails and phone calls and video conferencing, not. And the rule of law that's really established, that's been established over the years, the question courts ask is whether or not the use is truly a business use, or whether it is merely incidental to the residential purpose of the property. That's kind of the rule of law that Texas courts have adopted over the years. So let's get into a little bit of the factors here. Okay, so here's one factor. If you are having multiple deliveries and shipments and increases in cars parked on the street, in your yard, clients coming in and out, employees coming in and out, shipments being stored all over the place, those factors tend to suggest it is not merely incidental to the residential use of the property, but is in fact a business use of the property. So in that instance, if you're getting all those things, that is more than likely going to be considered a business use of the property and thus not allowed.
Being careful with this. I mean, this looks like my house every day off Amazon deliveries.
So again, noise, increase in trash, cars parked in the streets, signage in the front yard, basically advertising for this company. Number one, does it violate rules other than residential use only? Maybe you've got parking restrictions. Maybe you've got signage restrictions or noise restrictions or trash restrictions that you can hang your hat on. And I say that because the business use restriction is very, very hard to prove up. To Mitch's comment just now, Mitch can argue, look, I get 10 packages in my house 3 times a week because we purchase on Amazon. We purchase groceries and everything else on Amazon. That doesn't mean it's a business use of my property. So as you can imagine, it is very subjective to try to prove up that business use. Whereas parking, if you've got parking restrictions, it's pretty black and white. Here's the restriction. Are you parking in violation of the restriction? If the answer is yes, then you have to stop. Noise can be a little bit more difficult because it's very subjective. If you've got a lot of owners complaining about the noise, then maybe you can do something about it. Trash, again, many times it's a little bit more objective. Is there trash in and around the yard? If the answer is yes, then you've got to stop. All right, so again, specific policies and restrictions to prohibit the activities. Look to zoning ordinances. Sometimes, and again, this depends on the city you're in, right? Some cities you report a ordinance violation and it takes them 3 to 4 months to really take action. Other cities may take action for you. So that is another another arrow in your quiver or tool in your tool belt that you can use to get your restrictions enforced. Basically reporting the violation to the city, to the ordinance division for them to seek enforcement through a code enforcement officer. All right, so overall for community associations, let's talk a little bit about short-term rentals. It really is a no one size fits all. We have some communities that may be okay with a 6-month lease or greater. Other communities that do not want anything less than 30 days. I've got some communities that do require a 1-year lease. So it really is all about what your community members want to see as it relates to short-term rentals. And if you've got the community support to restrict short-term rentals, the strongest way for you to do that is to amend your declaration. Remember the house rule for single family and townhomes and the floor rule for condominiums. As it relates to adopting policies, if you are a Chapter 204 community, i.e. in the Houston area or Galveston area, then you can rely on that Court of Appeals case to adopt a rule. Get with your counsel, though. I strongly recommend you do that because there are some basically some traps you've got to run to make sure you're doing it right. So you're strictly in compliance with that Court of Appeals case and Chapter 204. If you are not one of those counties or areas, you're in Dallas, Fort Worth, the Hill Country, then you may be able to adopt a rule in accordance with that Court of Appeals case, but you have to have some really broad rulemaking authority, and you cannot really speak to leases in your declaration. If the answer to that is yes, then again, get with your counsel. You may be able to rely on that Court of Appeals opinion to have a board-adopted short-term rental policy. Again, keep in mind, it may be subject to challenge because the law is not well established on that. Swimply, maybe you're seeing it more, maybe you're not. If you love the idea of Swimply for your common area pool, make sure you've got the authority to do it because sometimes your restrictions are worded so that the amenities in common areas, if you're single family, or just common elements if you're a condominium, are only for the use of its members and its guests. So the association may not be able to expand usage beyond members or their guests. So again, speak with your counsel, work with your management team over at Goodwin to see if that's something you can really navigate. Swimply for individual lots, maybe it's an issue, maybe it's not. But if it is starting to become an issue, again, get with Goodwin, get with your council. There may be ways to enforce without even having to adopt a rule or amend your deed restrictions. And I think that's pretty much it. Finally, we've got we're a member of what's called the TCAA. We're on the board for the Texas Community Association Advocates. That's the lobbying group for community associations. So we're going to be looking for to see what the legislators are going to be doing for 2021. And it really is up in the air. We're going to start seeing more action in January. November is kind of when it opens up, but we really don't see much in the way of action of bills being introduced until January of next year. And it really is up in the air. Maybe the legislators are only going to be focusing on COVID-19 and ways to change and address the laws in that area. But we could see laws attacking community associations. So we offer legislative updates on a monthly basis. If y'all need that, Goodwin may offer that as well. Mitch.
Yep.
So, yeah.
Yeah, and certainly something, Clint, board members that want to be involved in TCAA, opportunity to just kind of be a part of that group. Where can they find more information on that?
So let's see, I'll give you the website here on TCAA.
And I will say, I mean, whether it's that CAI, which Clint's a big part of, for those board members who are interested in just being a part of the lobbying efforts and find community in trying to defend the position of community associations, so important to get involved from that standpoint. Certainly, Airbnb, VRBO, big dollars that they're generating and have a lot at stake in terms of bringing their lobbying efforts to the state to be able to change restrictions. So something that we'll continue to monitor. The other thing I would say before we wrap is that one thing that I'd want board members to know and kind of come to understand is that if you do find yourself in a situation where you're having to go get out a vote to affect change, if your documents require such a change, is that you might find that many of the members in your community would be opposed to restrictions, and it might be very difficult to get a vote of the membership in order to be more restrictive on this front, largely because, and I think we're starting to see more and more as communities come out of the ground, more and more marketing of the ability or flexibility to be able to lower restrictions to allow folks who want to buy a home in a community to be able to rent these out and generate income. So it'll be interesting to see how things evolve. I think many of the well-established communities certainly want to restrict this type of behavior or activity in a community, but there is this new wave, and as demographics continue to change in communities, there is this new focus to allow for greater flexibility. I think you're starting to see that certainly on condos in the more urban areas, but there is I think just a lot of attraction around the idea that give homeowners the control to do what they want in terms of generating revenue on these types of rentals.
Absolutely. And as Mitch mentioned, again, maybe your council has good legislative updates. We've got legislative updates. Y'all are welcome to get educated that way. And then TCAA, the website is txcommunityassociationadvocates.org. But if you just type in TCAA, it should pop you up with that website, so you can get involved. Because as Mitch mentioned, we do a big walk down to the Capitol in March or April every legislative session, and we love having community association volunteers and board members present and speaking about some of these bills that are going to affect communities, because the representatives and senators really want to hear from their constituents. I speak to the senators and representatives and try to, bring it down to the real legal issue, But what they really want to hear is from their constituents. And that's why it's so important for y'all to help contribute. So if y'all are interested in that, absolutely. I think you would be a really big help for TCAA and the legislative session next year.
Yep, we'll send that out with a link to this recording after today's call. For those of you who had questions, I don't actually know. I got my first question, but our screen froze somewhere, or at least the Zoom controls froze during my meeting. So I apologize for those who have asked questions and I haven't been able to get to them. I don't think there have been any questions, but in the event that there are, please go ahead and send me a message. We'll wait around a couple minutes for those to be typed up and sent through the chat function in Zoom. But yes, we will be recording this webinar and we'll be posting it on our Facebook page. I'll also send out a link to the recording on via email to all those that registered. Feel free to share that with any members in your community or any members of your board who weren't able to attend. And Clint, to your point, as soon as the legislative session starts to ramp up, would love to have you back on here to talk about what we can expect from this session, some of the hot topics that communities can expect, and ways that we can just get more actively involved and engaged in what's going on. To your point, it's important that we have strength in numbers and protect the interest of what's going on in community associations.
Absolutely, Mitch. Absolutely. Well, thank you all for having me.
Thank you. With that, we are hitting the hour. If you have any questions, please feel free to send those to me. You can reply back to the email recapping this session, and I'll be sure to get Clint included on that if there's a question that I can't answer. But Clint, appreciate your time. Thank you so much for your generosity in coming on and talking to us about these short-term rentals. Hopefully we cleared the air a little bit. Hate to see all that stuff on the web that just is so confusing for so many, and appreciate the opportunity to clarify this and also introduce us to some new sites that now we have to start worrying about, like pool rentals, which is great.
You're very welcome, Mitch. Thank you all, and enjoy the rest of y'all's day.
Thank you. Appreciate it.